The House Oversight Subcommittee on Weaponization of State Government will come to order. Will the clerk please take attendance?
Chair Regas.
Here.
Representative Shriver. Wolford. Pulaski. Here. Lugella. Here. Madam Chair, you do have a quorum.
Thank you. Representative Wolford moves to approve minutes from the February 24th meeting without objection. Oh, Wolford left. Sorry. Okay. Let's start that again. Representative Shriver moves to adopt the minutes from February 24th meeting without objection, so ordered. So good morning. Today, the Michigan Oversight Subcommittee on Weaponization of State Government convenes to examine a case that strikes at the heart of public trust, the ongoing prosecution of Attorney Matt DePerno by the office of his 2022 electoral opponent, Attorney General Dana Nessel. Because this remains an active criminal case, more than 2.5 years after the indictment, Mr. DePerno is strictly limited on what he can say. What is not limited is the record, a preliminary examination that still has not concluded, repeated delays, and growing speedy trial concerns. When the process itself becomes punishment, targeting a political rival and election integrity advocate, the rule of law is turned into a political weapon. We are here to ask one simple question: is this justice or is this retaliation? Mr. DePerno, thank you for appearing. You may proceed.
There you go. Thanks. Thanks for having me today. Good morning. My name is Matt DePerno. I was the Republican nominee for Michigan Attorney General in 2022, running against incumbent Dana Nessel. On July 19, 2023, I was indicted on 4 felony counts for undue possession of a voting machine and conspiracy. Those charges remain pending today. I have not yet received a preliminary hearing. Through this experience, I have learned something important. The burden is not only in the allegations, it is in the process itself. A prolonged indictment carries financial cost, reputational damage, professional disruption, and political consequence, all before any determination of guilt or innocence. I want to be clear about why I'm here today. I'm not here today to argue my innocence. I'm not here to litigate pending matters. I'm here to discuss the process. Specifically, whether the exercise of prosecutorial authority in my case reflects neutral enforcement of the law or whether structural features of that process indicate something else. This morning, I want to address the conflict created when the Attorney General investigated her opposing counsel in active litigation, who later became her political opponent. Biased public statements calling for punishment of attorneys who challenged the 2020 election, recorded discussions concerning venue and forum selection and charging strategy based on jury composition rather than law, the appointment of a special prosecutor after a declared conflict, violation of statutory privilege, the use of a grand jury in what was described as a multi-county matter, the role of outside coordination during an election cycle, and the funding and structural implications of those decisions. At the end, I will ask a simple question. Does this process reflect neutral, even-handed application of the law, or does it reflect something that should concern this body? This story starts in Antrim County, Michigan, a county of roughly 22,000 registered voters. On election night in 2020, the county reported results that were inconsistent with its historical voting patterns. The following morning, my client, Bill Bailey, asked the county clerk how that outcome occurred. He was told the results were accurate and the equipment must be trusted. No verification occurred, only trust in the system without question. Mr. Bailey disagreed. On November 23, 2020, I filed a complaint titled Bailey v. Antrim County, seeking judicial review of the reported results. As is well known, the 2020 national election generated significant litigation across the country. Many cases were dismissed on procedural grounds. The Antrim case was different. On December 4, 2020, the Circuit Court granted a temporary restraining order and authorized a forensic examination of the election management system. To my knowledge, it was the only case in the country where a court permitted a forensic image of election equipment through judicial process. This case drew national attention. 5 days later, on December 9, 2020, the Michigan Attorney General intervened. From that point forward, Dana Nessel, through Assistant Attorney General Heather Meingast and Eric Grill, appeared as opposing counsel in active civil litigation against me. And this is important. I want you to remember those names, Heather Meingast and Eric Grill. That fact is critical. From that date forward, the Attorney General was not an observer. She was my opposing counsel. On December 14, 2020, with court permission, I released a preliminary forensic report. Following the release of that report, the case became nationally visible. It was no longer simply a local county election matter. It was operating in a highly charged national political environment. In fact, the report landed on President Trump's desk that afternoon, and that context matters. On November 20, 2020, even before I filed that lawsuit, the Attorney General publicly stated she was considering a criminal probe into officials who would bend to Trump's will on overturning election results. And this became a theme for Dana Nessel. By December 9, 2020, she had intervened in the Antrim case as opposing counsel. And during that same period in which the case was escalating nationally, her office began investigating me. You will see today that the Attorney General was laser focused on prosecuting the issue. She only needed a defendant. The Antrim litigation proceeded through discovery. 21 expert reports were filed pursuant to the court's forensic order. The Attorney General's office received and reviewed those reports. No motion was ever filed alleging that the investigation exceeded the court's authorization. On May 19, 2020, the case was dismissed, stating that state law provided no available audit remedy. Significantly, though, the court in that case stated, "Nor am I saying that the processing of election data here wasn't corrupted or corruptible. I don't have the facts to make that determination. The plaintiff's reports and the news of the day, including a computer hack recently on a main petrol fuel pipeline on the East Coast, might well suggest that this is something that policymakers should be looking at into the future. If election results were to be held for ransom in the future, one can only imagine what would happen. I am saying that, as pled, the plaintiff's request for an audit is not available." Indeed, the court was asking for the legislature to get involved. The Antrim case remained active until December 9, 2022, when the Michigan Supreme Court denied review. Why does this timeline matter? Because the investigation that ultimately resulted in my indictment occurred during the very same 2-year period in which the Attorney General was my opposing counsel in that litigation. It is that overlap between active civil opposition and criminal investigation that raises the structural concerns I will address next. That overlap is foundational. During the Antrim litigation, the Attorney General's office initiated investigative contacts with a private investigator and several individuals identified on my expert witness list. Those contacts did not occur through civil discovery process. They occurred in the context of a criminal investigation that was developing while the civil case remained active. The contacts were done in secret, without my knowledge, and with the threat to the witnesses that if they did not cooperate with the Attorney General, they would be charged. Those individuals were interviewed by a team assembled by the Attorney General while the civil case was still pending and while she was my opposing counsel. That team included Eric Grill, whose name I mentioned previously, and Danielle Hageman Clark, who at the time served as the division chief of the Criminal Trials and Appeals Division. This is where MCL 49.158 becomes central. The statute provides that no prosecuting attorney shall prosecute or aid in prosecuting a person for an alleged criminal offense while engaged in a civil proceeding arising from the same state of facts, directly or indirectly. Again, at the time the investigation began, the Attorney General was actively litigating against me. The subject matter of the investigation arose from the same forensic work authorized by the court in that civil case, and members of her office were simultaneously appearing as civil opposing counsel and participating in criminal investigative interviews. The criminal charges later brought against me arise directly or indirectly from the same factual nucleus as the Antrim litigation. MCL 49.158 exists to prevent precisely this overlap, where the government is engaged in civil litigation against an opposing party while also directing or aiding in a criminal investigation arising from the same facts. The structural concern is not rhetorical, it is statutory. It exists for a reason. The statute protects structural fairness, including the integrity of attorney-client relationships and neutrality of prosecution. That overlap persisted from the beginning of the investigation through the end of the civil case. Now, while serving as my opposing counsel and while investigating me, the Attorney General made repeated biased and disqualifying public statements about attorneys who filed election-related lawsuits. On January 4, 2021, during an appearance on WDET 101.9, host Stephen Henderson compared lawyers who filed election lawsuits to violent extremist groups targeting the government or the governor. The Attorney General responded, they should be held accountable in exactly the same way. On January 28, 2021, Dana Nessel issued a press release. She stated that attorneys who filed election lawsuits fueled the fire of distrust in our democracy that led to the attack on the U.S. Capitol on January 6. That same day, media outlets reported that her office had launched an investigation related to the Antrim litigation. In July 2021, she publicly confirmed that she was investigating me. This was done in the context of her worldview that attorneys who challenged election results were bad people. How many times did we hear her say that people who filed election lawsuits were threatening democracy? I announced my candidacy for Attorney General later that month. I was endorsed by President Donald Trump on September 16, 2021. On February 11, 2022, she referred to me as an insurrectionist. On May 18, 2022, she posted statements describing me as fomenting domestic terrorism and supporting extremism. She also posted a video falsely asserting that I was in Washington, D.C. on January 6, 2021, plotting to overturn our election and encouraging an insurrection. The video she posted linked lawyers like myself to domestic terrorism and extremism. Although I was in Washington that day, I was not or near the Capitol. On July 23, 2022, she again publicly connected election litigation to deadly violence and called for attorneys behind those lawsuits to be penalized, including losing their law license. In that same messaging, she stated, "If you threaten our democracy, I'm coming for you with the full force of law." Filing a lawsuit was, in her view, a threat to democracy. Again, these statements were made during the period in which she was my opposing counsel in civil litigation. Her office was conducting a criminal investigation into me, and I had become her declared political opponent in the upcoming election. Public officials are free to speak, but when a prosecutor publicly characterizes the subject of an ongoing investigation, who is also her opposing counsel and her electoral opponent, as an extremist and domestic terrorist who must be punished, it raises legitimate concerns about neutrality and prejudgment. It raises questions about her agenda. The pattern of statements is part of the broader context in which this prosecution unfolded. On April 18, 2022, the Attorney General's office conducted a recorded proffer interview of private investigator Michael Lynch. Present at that meeting were Assistant Attorney General Eric Grill, who had entered an appearance in the Antrim-Citable litigation, Assistant Attorney General Danielle Hageman Clark, multiple members of the Michigan State Police. The interview occurred while the Antrim civil case was still pending and while the Attorney General was my opposing counsel. During that proffer, Mr. Lynch was asked to leave the room at one point. The recording device, however, remained active. In discovery in the criminal case, the prosecution produced a certified transcript of the recording. And you see here on that picture, it is certified by a court reporter. However, the transcript itself omitted 7 minutes between page 136, lines 2 and 3. The recording itself reflects a discussion during that interval. In that portion of the conversation, Eric Grill acknowledged that the individuals under discussion were experts in the Antrim case. There was a discussion about venue and forum shopping, including statements expressing a reluctance to try the case in Roscommon County and a preference for Oakland County. There was discussion about charging theories, including references to conspiracy and manufacturing a crime. There was acknowledgement of privilege concerns. There was acknowledgement of credibility problems with their main witness. And at one point, Ms. Hageman Clark later stated, "I know Matt DePerno is in play now." Let's see if that, I want to play that recording. Here we go. Do you know how to? Does this have audio? Well, we could play it from the. Oh, there you go. Hey, thanks. All right.
Can I direct you guys across the hall real quick? We're going to talk real quick and then we'll... Sure.
Yeah, well, let me, there's the timeline. Okay, thanks. I'll do this. I'll try and do this.
So is Brackenberg, he was the guy in your frontline video that you sent, right? The guy with the place down in South Carolina, the house where everybody came to, and
Yeah.
he was the big money. Yeah.
It all comes full circle.
Right?
Once you get it to the appropriate volume, can you restart it? Because we have members here that are engaging in conversation. I want to make sure that they can hear this recording.
Lindbergh and Rose are all the experts from the Antrim case.
Yeah,
Those
they're all the
names with
exhibits.
them.
Let me, there's the timeline. Okay, thanks. I'll do this. I'll try and do this.
So is Brackenberg, he was the guy in your frontline video that you sent, right? The guy with the place down in South Carolina, the house where everybody came to, and
Yeah.
he was the big money. Yeah.
It all comes full circle.
Right?
Do all these names sound familiar to you, Eric?
Oh, no, yeah, the Cotton, Lindbergh and Rose are all the experts from the Antrim case.
Yeah,
Those
they're all the
names with them.
exhibits.
Oh, yeah, I know those guys. I read the reports. It seemed weird at the time. It still seems weird. You know, that when he describes them as paranoid, I'm like, yeah, that fits.
Hey, they're buying burner phones and switching hotels and they have security. Like, is this just a money grab? That's what it feels like. It's like this
Yeah, I just,
Brackenberg has
like-
got money to burn, and so he's like, let's just get all the money.
Well, that's the start that starts to bleed into like the QAnon side of things, where like they're convinced that there's this upper level conspiracy. So if you buy into that, then all of this stuff becomes possible.
And common sense is just checked at the door. Okay, so what next? Anything else you guys want to ask them?
There might be stuff after we break it down, but I think I'm good for right now. I like him. I mean, he's full of good information.
Yeah, to me it seems like, and we can do however you guys want to do this, but if we can prosecute anybody in Oakland County versus Roscommon County, love you guys to death up there.
Yeah,
I don't want a jury up there.
Yeah, right.
Like, I'm not down with trying to pick no Roscommon jury. There's Lansing people. If we can pick an Oakland County jury, I'm not going that far.
I know, yeah, I'm like,
Listen, I really like Mary Beebe. I think she's a great prosecutor up there, but I don't want to be picking a jury of her peers up there
No.
on this kind of crap. Whereas if we can, charge them all with some kind of conspiracy, charge it down here because down here is where they're, diddling with the tabulators. I like that approach much better than trying to individually pick these guys off up in Roscommon.
yeah.
Even if it's conspiracy to, commit a legal act in an illegal manner for, or any of those other election fraud things we were looking at for DARE, ultimately it all takes place down here. I think that at least a part of the crime, arguably, is committed in Oakland County. And if we can rope them all into making them come down here to answer for it rather than up there in your guys' neck of the woods,
Yeah.
I think we have a better shot.
I think he's going to be good to work with. I mean, he's got timelines,
I do think he minimizes his involvement quite a bit, though. I was never
There's
told.
no way that he didn't know that he was committing criminal acts.
Well,
It's impossible. And I mean,
Burner
I'm not saying that
phones.
the guy is awesome as far as like the information he's giving, but it's absolutely absurd that he's walking into these places and getting these voting machines and he thinks that he's doing this, and it's legal. I mean, Stephanie's not a police officer as far as I know. She has
She's
no
a twit.
police.
She's such a twit.
I can't wait to look her.
But I mean, it's like
She's really pretty.
he's
She's
all
very
that we.
pretty.
I mean, he's going to give you everything. So it's just the whole thing of I didn't know I was doing anything wrong, but I was buying burner phones, and I'm naive, and it's like, no, you're lying.
No,
That's the
I mean,
only.
you've been doing security for
No reports.
Yeah.
I mean, that's how you get paid.
That's the job to have. No reports and just.
I mean, it's a
Thank you.
contract. Here's the scope of the work. This is what I'm doing. This is what I'm going to provide to
So
you.
it's just a matter of, if you guys are okay with later on Stephanie coming in and saying, absolutely, he knew he was committing criminal acts when he was doing this. We discussed it. We never text anything, which he obviously says. We never sent it electronically because we knew we could only talk about this in person. That would be something that would come out later. But and the other thing is even if they didn't talk about it, I think it's obnoxious, absurd to think that he didn't know it was illegal.
Yeah, so do we think we're on solid ground here in terms of like the attorney-client privilege that carries with him being her employee?
Well, he's a contract. That's
So
yeah.
what?
I mean,
Does that matter? I
I don't
you
know.
you could be a defense attorney, contract with a polygrapher, and there's attorney-client there. Like you, polygrapher, cannot then go out, call the prosecutor, and say, "Hey, this guy did it," because there's attorney-client privilege there. Now, there might be this whole idea of they're committing a crime together, and so you can't. There's no.
Rick was pretty. I mean, we threw that out right in the beginning.
So what
Can I direct you guys across the hall real quick? We're going to talk real quick, and then.
what was important about this audio that was not part of the transcript but was left out. First, Eric Grill acknowledges that he recognized the names of the experts in the Antrim case. And then Daniel Hageman Clark talks about venue shopping and forum shopping, specifically saying if we can prosecute anybody in Oakland County versus Roscommon County, love you guys to death up there, but I don't want a jury up there. I'm not down with trying to pick a Roscommon jury. Better pick an Oakland County jury. I'm not going that far. I really like Mary Beebe. I think she's a great prosecutor up there, but I don't want to be picking a jury of her peers up there. Then, later in that conversation, they recognize that there is an attorney-client privilege, and they're having a discussion about that. So they knew at that time that there was a privilege concern. They also recognized at that time that Michael Lynch, their expert, had problems when they said, he is full of crap. So I think those all raised legitimate concerns about that meeting. And then later in the conversation, I know Matt DePerno is in play now. Now, I'm not asking this body to resolve those statements. I'm asking you to consider their timing and context. This conversation occurred during an active civil case in which the Attorney General was my opposing counsel, while her office was conducting a criminal investigation arising from the same facts, and in the context of forum shopping, judge shopping, and manufacturing a crime, when Daniel Hageman Clark specifically says, charge them all with some kind of conspiracy as they try to figure out what the crime could possibly be. I want to also focus on the lead detective in the case, a guy named Detective David Geyer. He was present at that Lynch Proffer meeting that you just heard. But in a separate recorded conversation, he referred to the investigation as a political absolute shit show, recognizing, obviously, that the case was political.
The tricks. They're the ones pulling the tricks, including with you guys. You guys are being played to obstruct justice.
Well, there's no doubt about it. Well, they just dumped the entire voting investigation on me because all of a sudden after 6 months they have a conflict of interest, you know? So, I mean, I'm not, my investigation is probably not going anywhere because,
Well,
you know what? I realized that I got thrown in the middle of a political absolute shitstorm of an investigation. Okay? Absolutely. Do I think there was voter fraud? I do. Do I think it had anything to do with the ballot boxes? Absolutely not. Do I think it had to do with mail-in voting and absentee ballots and ballot harvesting? Absolutely.
That was not my characterization. That was his. One of the other investigators in the case is a guy named Detective Brian Fuller. Brian Fuller is a detective who works on Dana Nessel's Attorney General team. In September 2023, this is the same guy where a jury awarded a plaintiff $12,500,000 as compensation because he framed the defendant. That case was taken to trial on a 1983 claim, and the plaintiff won. These are the investigators that Dana Nessel uses. Now, on August 5th, 2022, the Attorney General's office filed a document in Oakland County titled Petition for Appointment of Special Prosecutor. Now, mind you, this is over a year after she started her investigation. The petition was addressed to the Prosecuting Attorney Coordinating Council, or PAC, and cited MCL 49.160. The petition stated that the Attorney General's office had completed a preliminary review and that it was time for a prosecutorial charging decision. Now notice, she didn't go to Karen McDonald in Oakland County with this. But this petition further stated that when the investigation began, there was a conflict of interest, but that there was not a conflict of interest, but that a conflict had since arisen. We know this to be false. She had a conflict the entire time. At this point, she declared her entire office conflicted over a year after her investigation began. The petition also provided that upon appointment, all costs of prosecution would be borne by the Michigan Department of Attorney General. Again, we know that Oakland County prosecutor Karen McDonald did not prosecute this case. We know she never declared a conflict. Now, our system is designed around the process that a county prosecutor can bring a case in the county where an alleged crime occurred, or the Attorney General can take up the case if there's a statewide implication. When the county declines and the Attorney General is conflicted, that should end the inquiry. There is no process in our system for the Attorney General to overlook a county prosecutor and bring in a collaborator elected in a different county. But this petition requested that a special prosecutor from another county be appointed. On September 8th, 2022, PAC appointed the Muskegon County prosecutor, D.J. Hilson, as special prosecutor. This raises several structural questions. First, PAC was created under the Prosecuting Attorney's Coordinating Office, MCL 49.101 through 49.111. Its duties are set forth in 49.109, and this says that the council shall keep the prosecuting attorney and assistant prosecuting attorneys of the state informed of all changes in legislation, law, and matters pertaining to their office, to the end that a uniform system of conduct, duty, and procedure is established in each county. MCL 49.110 sets forth the powers of PAC. These powers and duties primarily describe advisory, coordinating, and educational functions for county prosecutors. If we look at the website for PAC, it tells us what they do: continuing education, legal publications, legal research assistance, automated work management systems, and administration of grant-funded services. No other powers are enumerated or granted by the legislature or listed on the website. There is nothing at all about appointing special prosecutors. However, Dana Nessel requested that the prosecutor be appointed pursuant to 49.160, which was cited in the petition, but that appears in a different chapter of the statutes. It addresses circumstances in which a prosecuting attorney may request the Attorney General to appoint a special prosecutor, and circumstances in which the Attorney General may elect to proceed or appoint a prosecuting attorney. This has nothing to do with PAC. In the end, there is absolutely no authority for PAC to appoint a special prosecutor. Now, MCL 49.160, which is the statute under which DJ Hilson was appointed, this statute specifically deals with a county prosecuting attorney who has a conflict. In that case, that county prosecutor may request the AG appoint a special prosecutor. 49.1602 states that if the Attorney General determines there is a conflict, the AG may elect to proceed or appoint a special prosecuting attorney. The statute does not describe a process by which PAC appoints a special prosecutor after the Attorney General declares herself disqualified. In this case, again, the Attorney General declared a conflict. PAC appointed a county prosecutor outside the county where the alleged conduct occurred, and the Attorney General's office remained financially responsible for the prosecution. That sequence raises questions regarding statutory authority and the interaction between MCL 49.160 and the Prosecuting Attorneys Coordinating Office Act. It raises broader constitutional considerations under Article 3, Section 2 of the Michigan Constitution that divides governmental powers among the legislative, executive, and judicial branch. Here, Dana Nessel declared she had a conflict and then used MCL 49.160 as a vehicle by which to have PAC appoint her friend and collaborator, DJ Hilson from Muskegon County, as a special prosecuting attorney. That authority is not given by statute. It was created by the executive branch to achieve a goal. In addition to questionable statutory authority, there is a question of cost. The appointment happened on September 8, 2022. The petition states that all costs of the prosecution are to be borne by the Michigan Department of Attorney General. When the Attorney General declares herself disqualified, but her department remains financially responsible for the prosecution, that raises important appropriation questions. What is the funding source? Under what statutory authority are those funds expended? Was a specific apportionment made for this prosecution? And what is the total cost to date? The Michigan Constitution vests the power of appropriations in the legislature. Under MCL 141.436, expenditures of public funds are governed by the General Appropriations Act. If a prosecution is proceeding outside the ordinary county framework, and if it is funded by a department that is declared itself disqualified, the legislature has a legitimate interest in understanding the statutory basis for those expenditures and the total public cost for the prosecution. The question is about whether a funding structure for special prosecutions is transparent, authorized, and subject to legislative oversight. In this case, I submit that none of that is true. You don't even know what the costs are at this point because the Muskegon County prosecutors are holding their billing. And the next issue I want to address is the grand jury procedure used in this case. Following his appointment, the special prosecutor filed a petition in Oakland County Circuit Court seeking to convene a grand jury. Grand jury's authority is governed by statute. MCL 767.7 states that a circuit court judge may convene a grand jury for offenses occurring within that county. However, 767.7b addresses circumstances in which alleged criminal conduct spans 2 or more counties. In that situation, the statute provides that the Attorney General may petition the Court of Appeals to convene a multi-county grand jury, or 2 or more county prosecuting attorneys, with approval of the Attorney General, may petition the Court of Appeals for such a grand jury. The allegations in this manner involved conduct that was described at various points as occurring in more than one county. Despite that, the special prosecutor and the Attorney General's office, who desperately wanted this case to be filed in Oakland County, petitioned the Oakland County Circuit Court rather than the Court of Appeals. I'm asking today for this body to examine what happens when the statutory framework governing grand juries, particularly in multi-county matters, was not followed. And when that procedure is then combined with an Attorney General investigating her opposing counsel during active litigation, public statements calling the Attorney General, or public statements calling that attorney a domestic terrorist who must be punished, a declared conflict followed by an unconventional special prosecutor appointment, and the prosecution cost borne by the very office that declared itself disqualified. This body controls appropriations. This body defines statutory authority. The legislature must consider whether government resources are being deployed in a manner that is structurally neutral or in a manner that appears directed at a political opponent. A central witness before that grand jury was Jonathan Brader. He's the director of the Bureau of Elections within the Michigan Department of State. At the grand jury on March 7, 2023, he testified that the Bureau of Elections works under the Secretary of State as the chief election officer. That the director of Bureau of Elections works under the Secretary of State as the chief election officer. He testified that as the chief election officer for the Secretary of State, he has supervisory control over the election officials. He stated that local clerks are required to follow his instructions and that he is vested with the authority of the Secretary of State to provide those instructions. And he testified that he had established a rule on his own in this case that the only people authorized to possess voting equipment are voting system vendors, people granted permission by the Secretary of State, or a licensed contractor. None of those items appear in the statute. And again, he testified that he made up that rule with his own authority. And based in part on that testimony, the grand jury returned an indictment on July 19, 2023. What is relevant here is the legal status of agency directives and the fact that Jonathan Brader was a defendant in 2 cases that had previously resolved those issues in direct opposition to his testimony. One of those cases was Janetsky v. Benson, a Michigan Court of Claims case that held that agency standards amounting to substantive rules must comply with the Administrative Procedure Act. The court stated a rule not promulgated in accordance with the APA's procedures is invalid. In another case called O'Halloran v. Secretary of State, the Michigan Court of Appeals and later the Michigan Supreme Court reaffirmed that only formally promulgated rules carry the force of law. The court stated, the APA outlines a formal process that must be followed for an agency to promulgate a rule that has the force and effect of law. I raise this not to relitigate those cases, but to note that the legal foundation underlying the theory presented to the grand jury without cross-examination involved the distinction between binding rules and agency guidance that were resolved when he testified to the contrary. Again, Jonathan Brader knew this when he testified. But then on July 11, 2025, in another case, Jonathan Brader testified and he was subject to cross-examination. In that case, he testified to the opposite. When asked about the Administrative Procedure Act, he stated that when rules do not go through the APA, they do not result in a sanction. He stated that criminal penalties do not attach if his unpromulgated rules are not followed. He testified that there is no express prohibition that says an election clerk cannot bring someone else in. And regarding MCL 168.932, the statute on undue possession, he testified that there is no provision in this statute that requires a VTSL lab, a court order, or a licensed vendor to access the tabulator. In other words, there is nothing that requires permission from the Secretary of State. Had Jonathan Brader presented this testimony to the grand jury, no indictment would have been issued. In a nutshell, his testimony to the grand jury was false. Even though the prosecutors are aware of the false statements at the grand jury level, they have done nothing about it. Based on this untrue testimony, the legislature must consider whether government resources are being deployed in a manner that is structurally neutral or in a manner that appears directed at a political opponent. Michael Lynch, who I've already talked about, who attended the proffer with the government agents, is a licensed private investigator under MCL 338.821. He also testified before the grand jury. Remember, the investigators acknowledged concerns about privilege during that proffer in that recording I played. The Professional Investigator Act provides that communications and information obtained in connection with an assignment carries an absolute privilege. That fact, as stated in the statute, actually criminalizes unauthorized disclosures and deems the information privileges. It states right here on the slide, any employee who willfully makes a report in respect to any work is guilty of a misdemeanor. I raise this issue because when the prosecutors called him to testify before the grand jury, they should have known his testimony was subject to an absolute privilege and potential criminal violations. But they did not seek instruction from the court. Arguably, every conversation with the Muskegon County prosecution is a criminal act to which the Muskegon County prosecuting attorneys are complicit. The question again is whether government resources are being deployed in a manner that is structurally neutral or in a manner that appears directed at a political opponent. Now, we cannot meaningfully discuss weaponization of government without addressing documents that became public in November 2025 relating to what was known as the Arctic Frost investigation. Arctic Frost was reported at the time as a multi-state and federal investigation concerning post-2020 election activity. Documents not disclosed until November 2025 revealed communications between the Michigan Attorney General's office and an outside organization known as States United Democracy Center. These documents revealed multi-state coordination concerning election-related and collaboration to pursue legal and professional sanctions against individuals labeled as election deniers. Direct references identifying me by name, continued communications after the Attorney General publicly declared a conflict in the matter, extensive, frequent, and regular communications between senior Michigan Attorney General staff, including Heather Meingast and Danielle Hageman Clark, and States United regarding election-related prosecutions, and common interest agreement among multiple states with Democratic Attorney Generals. Among the disclosed materials was a document referred to as an action plan, dated August 12, 2022, and sent by Heather Meingast. Remember, she was one of the attorneys of record in the Antrim litigation. And this memo was sent after Dana Nessel declared she had a conflict. This memorandum stated that in Michigan, Attorney General Dana Nessel is seeking a special prosecutor to consider charges against 9 people. One of the 9 is Matthew DePerno, the election denier, chosen by Michigan Republicans to run against Dana Nessel this fall. The language is not mine. The action plan is explicit. It identifies my candidacy, my status as her electoral opponent, the pursuit of criminal charges, and frames the matter in electoral terms. These groups, including the Michigan Attorney General, the Democratic Attorney Generals Association, States United Democracy Center, and major Democratic donors, collectively pursued a multi-state strategy to investigate, target, and prosecute lawyers, including myself, who litigated challenges to the 2020 election. I was specifically named in States United's action plan and repeatedly referenced in internal communications. I was discussed in one of their memorandums titled Trump, 5 Lawyers and Their Conspiracy Against Our Democracy. These documents also showed DAGA, the Democratic Attorney Generals Association, showed payments of $3.4 million to support Dana Nessel's political operation during the same period her office coordinated with States United and investigated me. The timing is significant. The Attorney General declared a conflict on August 5, 2022. The action plan referencing my candidacy and charges was circulated on August 12, 2022. The 2022 general election campaign was underway. The issue before this body is not whether advocacy organizations may exist. The issue is whether coordination between the Attorney General's office and outside partisan-aligned advocacy organizations with payment during an active political cycle while pursuing criminal charges against an announced political opponent reflect the neutral exercise of prosecutorial discretion. That intersection of prosecution and electoral context is central to the weaponization concern. I'm asking today whether the structure revealed in these documents, coordination during an election cycle involving a declared political opponent, is consistent with the neutrality that prosecutorial power requires. Because when criminal process and electoral politics converge in documented communications, the burden shifts to the system to demonstrate structural independence. That is the concern raised by these disclosures. The question then is, why was I prosecuted? On July 2, 2025, my counsel and I met with a representative of the Muskegon County Prosecutor's Office to ask a straightforward question. Why was I charged? At the meeting, we were informed that no clerk alleges that I contacted them, no clerk alleges that I requested any equipment, no clerk alleges that I possessed equipment. We were told that my role was described as, quote, starting the train rolling by filing the Antrim lawsuit. When I asked about culpability, it was described on a scale of 1 to 100 as a 2 or a 3. The theory, as explained to us, was that filing the lawsuit created an environment in which others later obtained access to equipment, and somehow I should have stopped that because I'm an attorney. I filed a lawsuit that was authorized by a court. I pursued discovery that was authorized by a court. And the causal theory presented to me was that filing that lawsuit set events in motion. To me, that is the very definition of weaponization. And it really brings back Dana Nessel's ultimate goal in this from the very start, which was to prosecute people she deemed election deniers and who she thought were a threat to democracy. Now, when a prosecutor investigates her opposing counsel during active civil litigation, publicly characterizes that attorney as a domestic terrorist who must be punished because he filed a lawsuit, declares a conflict after more than a year of investigation, participates in an unconventional appointment process, utilizes a grand jury procedure that raises statutory questions, coordinates with outside advocacy organizations during an election cycle in order to prosecute her opponent, and ultimately charges that attorney based on the fact of filing a lawsuit. The issue is no longer personal, it becomes institutional. This body must examine whether this process reflects neutral enforcement of the law, and if not, then why is the state diverting an undisclosed amount of tax dollars to it? If it does not, then legislative clarification is necessary. Because the precedent does not end with me, it defines the boundaries of prosecutorial authority when the target is a political opponent. That is the question before you. Thank you for having me today.
Thank you. That's a lot to unpack. So, well, first, I would like to open up the floor for questions at this time. Please remember to keep your questions germane to the subject of today's testimony. Like, Rep. Wilford? Okay. So what troubles me, there's many issues here that I find disturbing and greatly troubling. However, when AG Nessel publicly called you ethically challenged and tweeted that your stance was pro-child rape, soft on sexual predators, domestic terrorists, and of course the insurrectionists that has been thrown around for years now. This is during your campaign while she was investigating you. How does that still impact your life?
Well, certainly during the campaign.
Where's the proof that you are these things, though? That's what troubles me. Being an elected official, a public figure, is that oftentimes people in these powerful positions, such as the AG, can say whatever they wish, and there's never any sort of repercussions of that.
Well, there's no proof of any of that. I'm none of those things, obviously. Dana Nessel used a lot of that as campaign fodder. But more than that, she took it to the next level when she actually conducted a criminal investigation in violation of the law when I was her opponent in a civil case. That clearly violated the law. She did it anyway. And she did it to gain an advantage, certainly in the election at the time, to declare that she was investigating me and that somehow she wanted the general electorate to think I was a criminal. That was certainly a goal of hers. In the end, she actually went through with actual formal charges and an indictment, I think, to support that. But the indictment is as I've described today, just in the process, and I don't want to get into facts, but just in the process, it violates multiple state statutes in the way she conducted this. But more importantly, what she's also doing is using state funds to continue her vendetta. Now, Dana Nessel, as I've shown from the very start, even before I filed the lawsuit in Antrim County, she had come out publicly and stated that she was going to investigate any elected officials, and this was directed at the time to Speaker of the House and the Majority Leader for the Senate, because they paid a visit to Donald Trump in Washington, D.C. She stated she was going to investigate anyone who bent the knee to Donald Trump. That later carried forward to her worldview that anyone who challenged an election was somehow, as she termed it, an election denier, or was subverting the will of the people, or was engaged in an attempt to overthrow democracy. What's interesting about that is, as we know, that wasn't the Democratic position back in 2016. That changed in 2020. I could show you video of many Democrat elected representatives in 2016 challenging the results of that election. What's interesting is just Dana Nessel had this worldview that she had to prosecute someone because she didn't like the fact that there were lawsuits challenging the election. I was her opponent. She, in the end, indicted me because I filed a lawsuit challenging the election. And we know that now because the special prosecutor, in a meeting with me, stated that. He said, I got the train rolling, and because of that, I was prosecuted. This is an attempt to show every other attorney out there that if you file a lawsuit challenging the election, you will be prosecuted by Dana Nessel.
Thank you. Okay. Representative Wolford?
Thank you, Madam Chair. Thank you for being here and testifying. I think it's always important for us to remember that on this Oversight Committee that we're not to be biased and listen to all the facts that are before us. I have a question for you as it relates to the quote from AG Nessel, started the train rolling. But before I ask you the question, I think it's important for those that are watching and those on the committee to see that we have and see a pattern here. And we see a pattern in our main oversight where in the Cornack case, AG Nessel chose to not prosecute Cornack and in her own words say that she's up for a judicial appointment. And so, let's roll past this. So I have some concerns in seeing these patterns today of her involvement in areas that she shouldn't be pursuing. So my question for you is, the special prosecutor said she's started the train rolling. So does that show true independence from the AG Nessel in your eyes? And I hope that this question's also for this committee and those that are listening, but do you see that shows true independence?
Well, no, absolutely not. But to clarify, the special prosecutor said I started the train rolling. I started the train rolling, he said, when I filed the lawsuit in Antrim County.
Thank you.
That, in their view, because it was so, it received such national prominence at the time. It was the only case where a court ordered a forensic examination of an election management system. The report that we released on December 14, 2020, we released it about 9:30 or 10 a.m. in the morning. We know now that it landed on Donald Trump's desk by 3 o'clock with a memo to print and review that report. And it was sent then to the DOJ for review. Nothing like that happened in any other case. And that was, in my view, troubling for Dana Nessel, because her worldview, again, was that anyone who filed a lawsuit related to the 2020 election was somehow subverting democracy. She couldn't let that stand, and she had to do something about it. So the point that the special prosecutors were making, which I believe is a direction from the Attorney General's office, I do not believe for a second that the Attorney General, with her announced conflict, has in any way stepped away from this case. And we know that through the Arctic Frost documents, where we see repeated contacts about me after she declared a conflict. So in that view, what the Attorney General was saying was, if you file a lawsuit, if you start the train rolling, if you provide an avenue to get people thinking about the possibility that perhaps our elections should be reviewed, she won't allow that to happen. She will prosecute. She will shut that down. She will stop people's attempts to redress grievances with the government. And she wants all attorneys to know, and they do, that if you file a lawsuit, you will be prosecuted. That's the point of that comment. And then when I asked him, because in this case, culpability is an element, I asked what my culpability is. And at least the special prosecutor was honest when he said it's a 2 or 3 out of 100. In my view, that is no culpability. That is the fact that I filed a lawsuit as an attorney and I was charged with a crime for that.
Thank you so much.
Representative Pohutsky.
Thank you, Madam Chair. I have a question about, I think it's a bit more of a process question, but about the first MCL that you cited, 49.158, the piece about nor shall any attorney be permitted to prosecute or aid in prosecuting. Understood. I guess my question is, at what point does investigation end and prosecution start? Because in the petition for the appointment of the special prosecutor, the first point references the joint investigation between MDP and the Department of AG. And then the second point says that now that prosecutorial review is beginning, that's why they're seeking the appointment of the special prosecutor. So I understand your point about the MCL, but at some point there is an investigation and then prosecution. So what is that delineation that you allege was blurred or violated?
Well, let's see. Let's pull that up. If I can find it. Was it 49158, right?
Mm-hmm. I think it was the first one that you had cited up there, so it's pretty early in the... I'm sorry, I don't have your PowerPoint, so I can't help you find it.
Yeah, I know. I'm not great at this.
Nope, you're fine.
Just so you know, but...
Prior to that,
Here.
That's it.
So what's significant about the statute is it says at the end, nor shall any attorney be permitted to prosecute or aid in prosecution in prosecuting any person for an alleged criminal offense where he is engaged or interested in any civil suit or proceeding, depending on the same state of facts. So what the statute is talking about is where a prosecuting attorney is engaged in a civil litigation in a case, the prosecuting attorney is not permitted to prosecute or aid in prosecuting any person involved in that civil litigation. And there's a reason for that.
I know that like time is finite here, so I understand that part. That was completely clear when you initially explained it. My question is, are you asserting that investigation leading up to any formal prosecution is part of prosecution?
Absolutely.
Then how is that? How are we supposed to investigate crimes? Like the appointment of a special prosecutor is not unique to Dana Nessel or her office. So how is the state supposed to investigate crimes where eventually a recusal is completely appropriate in the appointment of a special prosecutor? But how is investigation supposed to occur then in your?
Well, an investigation can always occur. It just can't. It just can't occur. It can't occur in this context by a prosecutor investigating a opposing counsel, or if the Attorney General thought that an investigation was warranted, she could set up a discovery wall, section off a certain part of her office. She could do that. She could hire, as she has done many times, other attorneys to be special prosecutors. That's certainly permitted. And again, wall off any discovery issues. She could have done that. She didn't do that in this case. What she did was she had the very same attorneys who appeared in the civil case calling my witnesses in for secret meetings with their office in order to, number one, threaten them with investigation, then have them disclose legal strategy and send them back to the attorneys like as essentially as covert spies. That's not permitted. So that entire process is a disqualifying event for her office. She should have recognized that and set up some other type of method to conduct an investigation.
Okay, so you were an attorney, so your legal perspective is that investigation is part of prosecution.
Absolutely. It's always part of the prosecution, and even in this case, after Dana Nessel declared she had a conflict, she turned over her entire investigative file to the special prosecutor.
Well, obviously.
But
like that's not, of course, you're going to turn over your materials. I don't necessarily agree with the presumption that investigation is part of prosecution because investigations do not always lead to prosecution, but I understand that that's your position. Thank you.
Representative Shriver.
Thank you, Madam Chair. What reform would you recommend to stop future attorneys general from conducting lawfare against innocent Michigan residents?
Well, first, I think that this body should look into the appropriation issue for sure, and I'm not sure that the body has actually looked into what Dana Nessel is spending in this case, how much it is, or why the Muskegon prosecutors have submitted, to my knowledge, little to no invoices at all to this point. I don't think they want you to know. So I think there needs to be oversight and perhaps legislation that deals with that. But in the end, you guys control the purse strings on the Attorney General's office. And all I want to speak to is my case, not other cases where she's involved. But certainly this case feels like a vendetta. Certainly from my perspective, it is, based on what I know about the actual facts. I'm not here to talk about those. But the vendetta of Dana Nessel and what she's done, it's very vindictive. And I think the Oversight Committee should look into what she's spending on this case and decide whether that makes sense, or whether funds should be used in other areas for this state. I can't speak to that. I just want to raise it as an issue for you guys to look at.
Thank you.
Thank you. So if a special prosecutor would have been appointed immediately, how would that have changed this? Because we've seen other cases where she did actually create a firewall, but then obviously repeatedly violated that firewall. But all of this is really concerning because there was no firewall. There was no firewall. She had access to everything, and then after a year, why so long? Why not immediately?
Well, why so long, I think, is pretty obvious, because during that investigation, I became her political opponent. After I was endorsed by Donald Trump in September of 2021, Dana Nessel put out a tweet at that time or shortly thereafter, recognizing that I was the presumptive nominee for the Republican nomination because of the endorsement. She knew that. Many people in the Democratic circles knew that. Many people in the Republican circles understood that. She stayed on this as the Attorney General because, number one, her office had access to my witnesses in the Antrim case. No question about that.
She brought those witnesses in, as we have, part of that recording. The witness left, but she was threatening your witnesses and getting information about your case and your defense from those witnesses.
Correct.
Is that what kind of violation is that? I mean, is there not an ethical standard for Attorney General?
There are many ethical standards, and especially for prosecuting
Is she aware
attorneys.
of them?
I don't think so,
Okay.
and I've seen the Michigan Attorney Grievance Commission make no effort to enforce those rules against her. But I think the point I was trying to make was she stayed on this because, number one, she had access to all that information. She wanted access. I was her political opponent, and she was able to use it during the campaign. So it's one hand sort of washing the other on this, and she continuously came out during the election, during the campaign, and used this as a talking point. So she was, in a sense, using state resources at that point to indirectly finance a campaign issue for her.
And possibly influence an election.
Well, I think there's no doubt, the question is, how many points does that narrative shift in the general electorate when she's continuously claiming that her opponent is a criminal, and she's the one who controls the process on that criminal investigation. It's quite insidious when you think of it in those terms.
I know that we have our rules regarding state office and campaigning, how separate those must be kept at all times because taxpayer dollars. And from that, I will go with Representative Wolford.
Thank you, Madam Chair. As someone that sits on this committee in Maine Oversight and chairs state and local affairs, we have found time and time again taxpayer dollars being used to sue the taxpayers. And I understand that there are cases that need to be looked at. However, over a month ago, we saw a pattern, and so my office, we have put forth legislation that will limit the Attorney General on the amount that can be spent on suing its citizens without oversight approval and appropriation approval. And so this is something that is nonpartisan, that Democrats, Republicans, Independents should be able to get behind because it holds Democrat or Republican from this year forward all the way through to making sure that taxpayer dollars are not being wasted or overused against its people. So thank you for bringing that up today. Thank you, Madam Chair.
Thank you. Representative Wagala.
Close. Wagella.
Wagella.
It's all right. It's so just wanted to help establish the timeline. when were you first notified or made aware that you were under investigation from the Attorney General's office? What was like the date? We had a lot of dates, so I'm just having to make sure.
There was. I think she initially confirmed that in. I think it was probably July 2021 when she first made reference to an investigation into that litigation.
Okay, and my question is, well, I have two, but the first one is, so you would say that it's wrong for people running for AG or AGs to threaten opponents with lawsuits and imprisonment, right? I think maybe not the best place for our democracy to be.
No, I think for an elected official. I think Dana Nessel is an elected official. That's a lot different than a candidate.
So you would say, though, because I'm just looking at your tweet from January 12th, 2022, where you posted a photo of Dana Nessel in a jumpsuit and asked people to donate $5, $10, $25, or $50 to lock her up now. That's okay for people to do?
I'm not an elected official. I'm not paid by the state of Michigan. I'm a candidate running for office at that point. I think you're conflating the issues. Dana Nessel took this to a different level. Dana Nessel acquired information in violation of a statute by contacting expert witnesses, violating privilege, threatening expert witness with crimes, and then using information she obtained to benefit her campaign. That's a lot different. There's difference between political hyperbole and what she did. So I appreciate your question, but I think you're conflating the issues with all due respect. And there's to follow up on Representative Walford's question and Representative Shriver's question. This case ultimately has its impetus, and I talked about this a little bit with the Jonathan Brader testimony before the grand jury and then later where he changed his testimony. This case is about, in essence, the authority of the Secretary of State to simply issue memos, rules, and directives, even through her election manuals that she issues, without any oversight. Now, she's required, as we know, she's required to pass her rules through the Administrative Procedures Act, but she does that very rarely. The question then is what happens when someone doesn't follow a rule or a directive issued by her office. And I would submit to you that in 2012, this legislative body passed a law, it's MCL 168.31A. And that statute states, the Secretary of State shall prescribe the procedures for election audits that include reviewing the documents, ballots, and procedures used during an election as required in Section 4 of Article 2 of the State Constitution of 1963. That statute, 168.31, took the power to oversee elections away from the legislature and gave it to the executive branch through the Secretary of State's office. That statute, in my view, is an unconstitutional non-delegation of authority, and you should take your power back and repeal that statute. Stop giving the Secretary of State complete control over everything.
We have that issue with most governmental departments. Actually, their rulemaking abilities sometimes is not in the best interest of the residents of Michigan.
Well, in all fairness, the legislature loves to pass statutes that say, as otherwise promulgated by rules. In my view, it's lazy legislating. I
would say that not the new class, but our hands are tied, as you know.
Right, but when you allow executive branches to then set up rulemaking committees, which are then essentially now legislating, it becomes an issue, and it has become an issue in cases like this. our election code is a mess. I think we can all agree on that, perhaps. Many of the statutes in the election code were passed in the 50s. They're non-relevant these days. They don't mean a lot. The entire election code, if you read it from the front to the back, it's a mishmash of nonsense. It's basically a Frankenstein of rules that make no sense when read together. At some point, the legislative body should consider throwing the whole thing out and starting with something new that actually makes sense and considers current technology, which the current election code does not consider. The definitions used in that code and in the rules refer to things that don't even exist anymore. And I would just recommend that at some point, scrap what you have, start new, rely on people who actually know something about elections to write that, and start fresh, is my view.
Okay, we have one more question. Representative Wolford.
Thank you, Madam Chair. More so a statement off of your statement. I'm very thankful that we have a Speaker of the House, Matt Hall, who cares about oversight, and this is why we're here today. You were alluding to the fact of the fourth fictitious branch of our government that I say all the time. We have three branches, and this fourth fictitious branch, the administrative state, continues to rear its ugly head, and I can assure you from the Speaker of the House and the House Republicans, we are working on oversight and will continue to do so. Thank you.
Thank you. And the Supreme Court has been looking at that issue as well on the unconstitutional non-delegation of authority, and Justice Gorsuch has repeatedly stated that when the time comes, if the right case comes, hopefully the Supreme Court will declare that fourth branch of government to be unconstitutional.
Thank you. So how is this affecting you? Is this still affecting you financially and professionally? Are you getting, how's your practice?
It affects everything. You know, not many people want to hire the attorney that's got 4 felony charges against him. I have people come up to me and say, "Nice to see you. When did you get out of prison?" As if I ever went to prison. The narrative that's been created by the news media and Attorney Nessel's office, and the prolonged length that this has occurred without a preliminary hearing is devastating. No one should have to face this from someone who wields power like Dana Nessel, who is doing this simply to make a point and to be vindictive. It affects everything in life. It's kept me out of running for other offices. It wouldn't be fair to do that, neither to my family, myself, or even, I dare say, the Republican Party, to give the media those types of narratives to run against me. So, yeah, it's damaging in every way. I have other attorneys in cases I'm involved with use it consistently as a weapon. They bring it up to the judges to paint me as a bad guy. So all of that happens. And as you know, I get involved in some politically typed cases. I do constitutional work in federal court. So some of the opposing counsel I'm up against are, as I'd say, people from the other side of the aisle. And so they use it as a weapon, and it's given to them by the government.
And it's been 2.5 years without a preliminary exam?
Correct, without a preliminary.
What is the holdup?
The holdup is continuously issues of realizing that the prosecuting attorneys are not turning over discovery, violation of rules such as Brady and Giglio, not disclosing exculpatory evidence. Currently, the holdup is one of the issues that we have before us now, which is the violation of privilege and whether certain testimony and evidence is admissible or not. These are the holdup. There's nothing clean about this case in any way, procedurally or factually, at all. But it's, I think there is a a issue of a speedy trial issue at this point.
Sure.
And I'm here to raise these issues to the committee to say, I think you should look into what Dana Nessel's doing here, how much money she's spending and why she's actually doing this and what she's trying to accomplish.
Okay. We will send a request to the Attorney General's office to request records regarding this. However, because the case is still ongoing, we'll see what we can actually obtain. But obviously, we're happy to look into it more. And Rep. Wolford, he has legislation that they're doing. So we won't let it go. We're going to keep looking into this and see how we can make sure that this, I mean, unfortunately, you were like the spark that lit, that lit the fire of this topic with not only the election fraud, but the weaponization of state government pertaining to Attorney General Dana Nessel. So we will keep going on this for sure. And I would expect, correspondence from you back and forth on how we can work together to rein this in for you and for others, because no attorney should feel the threat of not being able to file a lawsuit pertaining to election fraud without the Attorney General. And our state government has become just a monster when it comes against the people of our state. And so that's part of the reason why oversight has been such a goal and focus for our speaker. I mean, the things that we've been able to do in oversight are just unprecedented. But I do have one final question before we adjourn. The Daniel Hagman Clark. So this attorney, explain his role in this case, because he's also so it's Danielle. She's also been involved with the Cornett case, which, as you know, the prosecutor out of Kent County is finally prosecuting Tracy Cornack for the embezzlement from the money from the elderly woman, and then also the case with Dana Nessel's wife, which appears to still be going nowhere. So is this can you just touch on this person quickly?
Well, Danielle Hageman Clark is who I would refer to as Dana Nessel's lieutenant, second in command, and what she did in this case is early on she coordinated with the expert witnesses. She brought them in, threatened them with criminal prosecution if they didn't cooperate with their office secretly. She manufactured a crime, trying to come up with something, as she initially stated, was diddling with computers. That's not actually a crime. It's not a thing. They had to manufacture and create a crime in order to charge it in Oakland County. They desperately wanted to be in Oakland County. She's also someone who we know from the Arctic Frost documents communicated with the DOJ, Joe Biden's DOJ, on issues, and with States United and the Democratic Attorney General's Association and the coordination of transfer of funds through those organizations and dark money PACs to coordinate an effort against attorneys challenging their law licenses and bringing litigation against them and criminal charges under the theory that they were all a threat to democracy. And we know that she continued to coordinate with those agencies after Dana Nessel announced that she was conflicted. She still did that and communicated about me and worked on the back end of this prosecution, in my view.
Okay.
I think the committee should look into the money that flowed into Dana Nessel's operations during the campaign from those agencies in order to fund that litigation. Dana Nessel's office essentially made States Democracy United a de facto wing of her Attorney General's office. They were, in one sense, the prosecuting attorney wing investigating and looking into these cases. And I think you'd find, if you really dug into that, significant violations probably of campaign finance.
Okay. After this hearing, we have a long list of things to request from the AG's office. So is there, we have to wrap up, but as a couple more minutes, is there anything else that you feel that you may have left out, or any closing statement that you would like to make briefly?
Well, when you try to get documents from Dana Nessel's office, I would submit to you that we've tried to do that, the process of discovery in the case through the special prosecutor's office. They seem to have somehow now, miraculously, enacted some type of firewall between their office and Dana Nessel's office, is what they tell us. So in other words, they refuse to actually go obtain actually exculpatory evidence from Dana Nessel's office. So I'd be very curious to see what type of information you could obtain from Dana Nessel's office that the special prosecutors allegedly are unable to obtain.
Okay. Thank you, Mr. DePerno, for your testimony. The people of Michigan did not grant the government the power to investigate its opponents and then stall justice for years at the preliminary stage. After 2.5 years, you deserve resolution. This isn't due process. This is absolute the weaponization process. So we will continue to demand accountability so that no attorney general, Republican or Democrat, can use their office to weaponize, and especially use that weaponization to benefit themselves on the campaign trail. So the people of Michigan deserve better. So there'll be no further business before the committee. The Oversight Subcommittee on Weaponization of State Government will stand adjourned. I'm sorry, I broke your pen.